When parents separate, it is really important that they put into place proper arrangements for the care of their children. Just because a spousal relationship has finished doesn't mean that parents stop being responsible for their children. Parents must always put their children first and ensure that their best interests are taken into account. Sometimes it's really hard for parents to make arrangements for their children. One of the ways that parents can do this is by going through family dispute resolution. This gives parents the opportunities to discuss issues that are important to them and also to their children. Sometimes parents are unable to reach agreements, and that is when these processes can be put into place. It is not intended to replace legal advice, and we ask that all parents do get legal advice if they have any questions arising. When parents separate, they need to consider what arrangements need to be put in place to ensure that their children are best looked after. Just because parents separate doesn't mean that you stop being a parent. You really need to consider what's the right thing for your children. What are in your children's best interests? This information is given as a background to the family law system to help parents navigate through the family law system. At separation, parents should consider what are in the best interests of their children. Best interests are defined under the Family Law Act in two ways. Firstly, there's the primary considerations, and then there are additional considerations as well. Primary considerations include children having the right to have meaningful relationships with both parents. Children should also be protected from harm, both psychological and physical. We need to make sure that our children are kept safe, and that is the most important thing. Some additional considerations which parents should consider include things such as children's ages, their views, their relationships with each parent and other significant people such as grandparents, their cultural backgrounds, expenses, practicalities, how children will move between parents. There are lots of considerations that the Act says we need to take into account and which the court will ask the parents to consider when determining the best interests of children. The law presumes that where parents have separated, they each have equal shared parental responsibility for their children. That is, if the parents are able to make decisions in the best interests of the children. It is a joint responsibility. Equal shared parental responsibility covers issues such as changes of name, health, medical, school, education, those types of things. So, whilst the law says that there is a presumption that both parents should share equal shared parental responsibility, in some situations that's not the way it will work, particularly where there has been violence or abuse or a risk of violence or abuse. Equal shared parental responsibility does not mean that children must spend equal time with both parents. It is a consideration which should be taken into account. However, it will be the children's best interests and what is reasonable and practical which must be considered. Where equal time is not appropriate, the law says that parents should consider children spending significant and substantial time with each parent. Substantial and significant time is different than each alternate weekend or half school holidays. Substantial and significant time includes times such as midweek, if children are at school, helping the children with schoolwork, and other special occasions such as birthdays, Christmases, Easters and those sorts of events. The law now says that it is a requirement for parents who have separated to go to mediation before they go to court. This is to help parents to try to work through these issues without just bombarding the court and asking the court to make those decisions when they haven't really turned their minds to those sorts of issues. It is a requirement, however, there are exceptions to going to mediation. Exceptions include where there is violence or a risk of violence, where there is urgency, where there is a breach of previous court orders, or where it's just physically impossible for that to happen. It's always a good idea for parents to get legal advice before they simply go to court. Where parents are able to reach agreement at mediation, there's really three things that they can do. Parents can just put into place informal arrangements, such as an oral agreement or a partly written agreement. The difficulty with informal arrangements are that it's quite hard for parents sometimes to recall what arrangements were put into place, and there can be some ambiguity or even some confusion. Informal arrangements are sometimes hard to prove, so that if parents later have to go to court Even though the court will consider the history or the status quo of what has happened, it's really what one parent says or what the other parent says as well. Parents can also make a parenting plan. A parenting plan is a written and dated document which is signed by both parents and also other important people such as grandparents. A parenting plan can include things such as where children will live, who they spend time with, and other significant information, such as how children will move between two houses. Parenting plans are not legally enforceable. However, if the parents or parties later have to go to court, the court must consider a previous parenting plan. Parents can also formalise any agreement that they reach at mediation by filing consent orders with the court. When consent orders are filed with the court and made by the court, they have the same force and effect as if the judge had sat up in a chair and made those orders to the parties. They are legally enforceable, and the orders that are made have legal consequences if they are not followed. Sometimes parents just aren't able to make agreements in relation to their children, and sometimes parents need to take their application to the court. Where mediation has not been successful, or if the parties have an exemption to attending mediation, they can bring an application to the court. Where parents have been through mediation and it has been unsuccessful, the Family Dispute Resolution Practitioner will issue a Section 60I certificate which entitles the parents to bring the application to court. Ultimately, it'll be the court that makes the decision in relation to the children, where parents are unable to do this. It is always a good idea for parents to seek legal advice before they bring an application to the court. Before parents and important people go to mediation, it is really important that they put themselves in the best frame of mind to make good decisions about their children. We always ask people to think about how they are travelling. Do they need financial advice? Do they need counselling? Do they need legal advice? If parents are in a good position, they are able to make good decisions for their children.